Hello everyone and welcome back to Naija Gist Gang, your trusted source for verified updates and insightful discussion on the most important stories shaping Nigeria today. I'm your host, Precious, and in this segment, we turn our attention to a compelling interview conducted by Arise News, featuring legal practitioner and analyst Frank Tietie. In this conversation, Mr. Tietie provides thoughtful commentary on the ongoing debate surrounding the professional conduct of lawyers involved in politically sensitive cases, particularly the question of whether participation in public protest should attract disciplinary measures such as disbarment. He sheds light on the delicate balance between a lawyer's constitutional rights as a citizen and their ethical obligations to the court, referencing both the rules of professional conduct and fundamental rights enshrined in the Nigerian Constitution. The discussion also touches on broader issues, from the role of the police in enforcing court orders to the persistent tension between human rights, political influence, and due process in Nigeria's legal system. Stay with us as we bring you highlights from this engaging interview, offering key insights into the intersection of law, justice, and civic responsibility. Let's dive into the full discussion.
Frank Tietie, a lawyer and Arise analyst, here to throw more light on these issues. Glad to have you. Always glad to have you.
Thank you, my pleasure.
In the studio. All right, so straight out, why do you stand for or against concerning the lawyers?
Why should we even contemplate the issue of disbarment as if that's the only kind of sanction you give to a lawyer? If you perceive that he's done something wrong, you can reprimand him, you can suspend him, you can do anything, but not disbarment. So I think, but that is very far from to be considered in this issue.
Has he done anything wrong?
No, absolutely not, because you must consider Aloy Ajimako first and foremost as a Nigerian citizen who's got rights as a citizen to demonstrate, to be part of a protest. And then two, he does in every way hold some measure of professional responsibility to both the courts and to the legal profession. There's no doubt about that. So we must therefore now make a distinction between his responsibility and rights as a citizen of Nigeria and his responsibility to the court. So did he in any way offend the court? When you say a matter is subjudice, it means that it's under consideration by the courts. And when you also say that lawyers, particularly under the rules of professional conduct, specifically rule number 33, should not, make public statements with regards to matters that they are involved in, it's clear, because the aim is that do not make such statements to either put pressure on the court, to influence the court, or influence the public. So what Aloy was doing by being present, just being present at a protest, at a rally, does that amount to in any way as putting pressure on the courts? Yeah, it doesn't in any way. Because, and then most importantly, did he organize a protest? Did he call for a protest? He was simply part of the protest. If I am working to free my clients, and then I see a number of persons who consider that my client is in detention today for political reason more than legal, and they are holding a rally, and I happen to be present there by way of any form of solidarity as a citizen of Nigeria, am I trying to influence the court? Am I trying to influence the judge? So the unfortunate thing, and we must know this, is that if we think that Aloy has gone past his remit as a professional, as a lawyer in a matter that is appearing in, and then which means virtually every senior lawyer, every lawyer who has spoken to the press immediately after leaving a court hearing has actually violated that rule. I hope we all know that. So yes, because those actions have been more prejudicial to the cases that they are appearing than whatever Aloy did, expressing his rights as a citizen of Nigeria.
Oh, well, that's quite interesting.
Of course it is, because the rule is quite clear. Anytime a lawyer makes a statement in public, when a case is anticipated or when a case is going on, especially when he is involved in a matter, it violates the subjudice rule. And we see it every now and then. Lawyers, especially senior advocates, as a form of one subtle advertisement or the other, is offensive to our profession. It's wrong. I, as a lawyer, will never make a statement concerning a matter that I'm appearing in. So we're doing all sorts of things, and then we've been accepting them, and then it comes to Aloy's own. Is it because it's involving Nnamdi Kanu now? We are now waking up some strange
Let me get you right. Are you saying that if you leave a court room, you cannot grant it?
As a lawyer participating in a matter, immediately in fact, there's an express rule against it, Rule 33 of the Rules of Professional Conduct, as amended in 2023. You cannot address the press with regards to the fact of the matter, with regards to any issue relating to that matter.
So, Frank, why is it occurring? Why is it happening?
Because it's against the subjudice rule. Even though it's a common law rule, we don't have any express statute against it. But they are all. But we have
no express statutes.
No, but again, how do you not look at what is the role or what is the status of the rules of professional conduct? It's express that you cannot address the press, and we do it all the time. And look, the courts accept it. The bar association accepts it. There is no reprimand. Nobody has reprimanded. It's wrong because there's room for journalists to be in the court all the time to observe proceedings, to take note of things, and they report in such a manner that it's not prejudicial, that does not undermine the integrity and the independence and impartiality of the court. But we see this every time being breached, and we don't have anybody raising dust. It comes to that of Nnamdi Kanu and the respected Aloy Ejimako is now an issue. So why should it be?
Before I go to my next question, just this one. All you're saying now, what does the Constitution particularly say about this?
Look,
I mean, it's the ground norm.
Yes, what the Constitution says. Under Section 39, the citizen of Nigeria has a right to hold opinion and express same. Under Section 40, the Nigerian citizen has a right to congregate, to meet anywhere in any part of Nigeria, and then express himself and take part in rallies. Under Section 41, he has a right to move about anywhere, go to Kafanshan, go to anywhere, and then express himself. He hasn't offended the Constitution as a citizen of Nigeria.
All right.
It doesn't exclude the fact that he has some professional responsibility to the Nigerian, to the bar, to the legal practitioner.
MBA.
Yes, I mean the legal profession. However, has he offended the court? Was he attempting to influence the court? Was he attempting to intimidate the judge? Absolutely not. He was present at a protest that was aimed at President Tinubu to take a political decision, ask your Attorney General to withdraw charges against Nnamdi Kanu, or rather release Nnamdi Kanu. How could that be offensive?
Right.
For goodness sake.
Fine. What do you even make of his arrest and the arrest of those who participated in this protest?
Oh, well, I found that quite sad. Very, very sad. You know, in any way, I'm careful because when we promote human rights, we try to balance it with the responsibility to also promote the fact that there has to be peace. I think that was tainted. You know, the point is that should he have been arrested? I don't know. I mean, but when the police gave a reason for arresting him, that he was present in a place where a certain court order, barred people from protesting. These are issues of fact. The point is that was he named in that court order? What was he doing? Just by being present, should he have been arrested? And again, what is the process? You know, in determining the criminality of whoever, what was wrong, or who was offending the particular order of court, should that be left to the court? I mean, we're talking about a legal practitioner who is, present at a rally, at a demonstration, a peaceful one, non-violent, absolutely not offending any known law. Why should I arrest him? Now, those are all the dimensions that point to the fact that this whole thing about Nnamdi Kanu is political. And I maintain that position. And that's the reason why its solution lies in the political power, and particularly that of the president.
Let me ask you this. The police say it is standard procedure to keep a suspect in custody until bail conditions are met, correct?
That's not very correct. The point is that the moment the police hands over a suspect or an accused person to the court, his job ends there. It's respect. Don't forget, the court has a bailiff, the court has a sheriff that takes responsibility of the accused person and determines. It's not the police that. There's this wrong procedure we experience all the time in court, where after bail has been perfected, you still have to take that bail, the perfected documents to the prosecutor to examine whether they are in accordance with the pronouncement of the court before the person is released. All sort of violation of our rights. The good thing about it is that this is happening.
This is a serious matter.
Of course it is. Absolutely serious.
Because this goes on and on. Are you saying that the police...
It didn't have any business anymore. The moment or whoever was as an accused person was handed over to the court...
Why does it keep happening?
Oh, because we have not challenged it. Because we keep, failing to observe known standards. And we allow them. The same way the lawyers violate the rule against them, the subjudice rule, anytime they make pronouncements, when they come out from court and the courts tolerate it. That's the same way the courts have tolerated their powers being, taken over by the police. The court is in the custody of the court. It's in the court to determine that, go to the police,
my time is gone.
Go to the prison or remain in court.
Okay, quickly. Is the police handling this right? Are Showore and his people, are they handling it right?
I think I'm sympathetic to the police. Those officers of the police force, because they have to obey certain political orders, even when they know that what they are doing is wrong. And then when you ask me as to whether Showore, I'm also sympathetic to Showore. In fact, I'm very sympathetic to him. I believe he's doing the right thing. Again, there is no restraint to the level.
Against the court order?
Well, the point is that I'm not aware whether he was served.
Even though he said he
but
wasn't
the point is
served.
this: if he has chosen to disobey an order of court, then let him face the consequences.
Okay.
And that consequence,
Good.
let me tell you. No, let me tell you.
No, I'm
It
not
is before
saying.
the
I'm
court.
not saying his. I'm just
It's
saying
before the court.
what you said.
Yes.
Yeah, I'm not saying. I'm just saying that. Very interesting submissions. Thank you so much, Frank Tietie, lawyer and Arise analyst. Always interesting to have you.
My pleasure.
Discourse. Like I said, you always vibrate.
Oh well.
What we have just heard from Frank Tietie brings to light one of the most complex debates within Nigeria's legal and democratic framework, the delicate balance between professional ethics and fundamental human rights. At the heart of this argument lies a simple but powerful premise. Lawyers are first citizens before they are professionals. As citizens, they possess the right to express opinions, to assemble peacefully, and to participate in civic life, as guaranteed under sections 39, 40, and 41 of the 1999 Constitution. Yet, as officers of the court, they also bear a duty to uphold decorum, protect judicial integrity, and avoid conduct that could compromise the impartiality of proceedings. Tietie's analysis challenges the assumption that disbarment, the permanent removal of a lawyer's license, should be the automatic response to alleged misconduct. He insists that disciplinary measures should be proportional, ranging from reprimand to suspension, and applied only when due process has been strictly observed. Anything beyond that, he argues, risks turning professional discipline into an instrument of intimidation rather than justice. He drew attention to Rule 33 and Rule 23 of the Rules of Professional Conduct, which prohibits public commentary by lawyers on ongoing or anticipated cases. While the rule's intent is to prevent undue influence on the courts, Tietie noted that its enforcement has been inconsistent. Many senior lawyers regularly grant interviews and make public remarks about active cases without facing sanctions. This inconsistency, he warned, weakens professional credibility and creates a perception that ethics are applied selectively depending on who is involved. Beyond the professional dimension, he also examined the broader constitutional and moral implications of the arrest and detention of lawyers and citizens during peaceful protest. According to him, participation in a lawful assembly does not constitute an attempt to influence judicial outcomes, nor does it violate the subjudice principle. In his words, the act of standing in solidarity with one's client or cause cannot reasonably be construed as contempt of court. Tietie questioned why the police continue to play an outsized role even after a suspect has been handed over to the courts. By law, the authority over an accused person's custody transfers to the judiciary once bail conditions are met. Yet, in practice, police officers frequently delay releases, subjecting suspects to unnecessary procedures. He described this as a persistent violation and a distortion of the rule of law, one tolerated for too long because institutions have failed to challenge it. His reflections on the Aloy Ejimakor case further underline the political undercurrents often influencing legal matters. Tietie maintained that the entire controversy surrounding Ejimakor's presence at a protest is, at its core, political rather than legal. For him, it symbolizes a broader pattern where legal processes are sometimes used to pursue political objectives. The real solution, he emphasized, lies not in punitive measures, but in political leadership, particularly at the level of the presidency, to promote justice, restraint, and national cohesion. From a broader perspective, this conversation exposes a recurring dilemma in Nigeria's justice system: how to uphold judicial integrity without suppressing constitutional freedoms. The subjudice rule is vital in preventing trials from being influenced by public opinion, yet it should never evolve into a tool for silencing legitimate civic expression. The challenge lies in enforcing ethical standards while preserving democratic rights, a balance every mature democracy must constantly negotiate. For Nigerians observing this debate, the implications go beyond the legal profession. The questions raised here touch directly on citizens' trust in justice, the independence of the judiciary, and the accountability of law enforcement. When lawyers, journalists, or citizens fear punishment for expressing lawful dissent, it signals a weakening of democratic resilience. When professional bodies enforce their rules fairly and the police respect judicial authority, it strengthens both the bar and the nation's constitutional order. Tietie's perspective also reveals how institutional complacency fuels their functions. The same tolerance that allows lawyers to breach ethical rules without consequences mirrors the leniency that lets security agencies overstep their bounds. In both cases, silence and inaction create space for abuse. The path forward, therefore, requires consistency, consistent enforcement of laws, consistent defense of rights, and consistent respect for due process. The conversation further invites introspection within the legal community itself. As Tietie observed, lawyers occupy a dual identity, advocates for justice and custodians of discipline. Upholding that balance demands integrity, humility, and courage. Integrity to act with ethical boundaries, humility to accept accountability, and courage to speak truth to power even when it is inconvenient. From a governance standpoint, this issue underscores the need for continuous legal reforms and clearer communication between the courts, the bar, and the law enforcement agencies. Judicial independencies cannot strive in a climate where police authority extends into courtroom affairs, nor can civic freedom survive in a society that criminalizes peaceful dissent. Ultimately, the message from this interview is not merely about one lawyer or one protest. It's about the health of Nigeria's democracy, whether our institutions serve justice impartially, whether our laws protect the innocent, and whether the system respects both authority and rights in equal measures. The discussion also reminds policymakers and citizens alike that rights and responsibilities are inseparable. Freedom of expression must be exercised with respect for the rule of law, just as state power must be exercised with respect for human dignity. The future of Nigeria's democracy depends on striking that equilibrium. As this matter continues to unfold, the hope is that the legal community will take this as an opportunity to reflect, to clarify boundaries, enforce standards, and defend the sanctity of both profession and constitution. True reform, as Tietie implied, will not come through punishment alone, but through consistency, fairness, and the courage to apply rules equally to all. What this moment calls for is restraint on all sides. From lawyers, a renewed commitment to ethical discipline; from the police, adherence to proper procedure; and from political authorities, the wisdom to separate justice from politics. Only then can confidence be restored in Nigeria's legal system and by extension in the rule of law itself. As always, we value your thoughts on this issue. Should lawyers face sanctions for attending public protests, or should their constitutional rights as citizens take precedence? Share your opinions in the comments below. Your perspective matters in shaping a more informed public dialogue. If you found this analysis insightful, please like, subscribe, and turn on notifications to stay updated on future discussions and reports. Your engagement helps us continue providing balanced and verified analysis on the story that matters most. I'm Precious, and this is Naija Gist Gang, where credible voices meet thoughtful journalism. Thank you for watching. I'll see you in the next one.